So we're going to talk about a married couple, and we are going to talk about a single person. Married couples, there are more options. So a married client, here is the example. And here's why I say I like those annuities, those Medicaid compliant single premium immediate annuities. Here is our example. They have an $800,000 estate. That sounds like too much for Medicaid, doesn't it? Because their house is worth $400,000 and they have $400,000 in a bank account. The house doesn't count. Take that off the balance sheet. The type of care they need is skilled nursing. When I say they, I mean one of the couple. So because it's skilled nursing, the community spouse gets to keep the maximum resource allowance, which is $148,000. Well, they bought $251,000 too much. What are we going to do? Take that $251,000 and you buy the Medicaid compliant annuity. In Washington, how that works is that you take the $251,000, which is countable. You bought the annuity, which is non-countable. They're resource eligible. That money comes back to the community spouse. And how it works in Washington is we take the $251,000, we divide it by 16 months. That's how you get the $4,189 per month comes back to the community spouse. If the community spouse dies before their Medicaid spouse, what happens? Well, we want to make sure we had good estate planning in place such that when the community spouse dies, that the assets of the community spouse don't go outright to the community spouse. If so, Medicaid spouse, if it does, the Medicaid spouse has way too much money, they're kicked off of Medicaid. Instead, they have the right kind of estate planning. The will has a supplemental needs trust in it. Because of that, when community spouse dies, all the assets, the house, the bank account, etc., go into a trust allowed by the state for the Medicaid spouse. Medicaid spouse stays on Medicaid. All the assets in the trust are there to enhance any care that's not being provided by the state. And then when the Medicaid spouse dies, none of that money in the trust is subject to estate recovery, and it all goes where the couple wanted it to go to their children, for example. So that is what I'm talking about. The will has to have the supplemental needs trust in it. If the community spouse had that Medicaid compliant annuity, like we just discussed, then, well, the state allowed you to have that annuity and convert countable assets to non-countable, but the community spouse died before the 60 months was up, before they got all their money back. So now what happens? Well, the state of Washington now is the recipient of those monthly payments until any amounts they paid on behalf of the ill spouse are paid back to the state. It's good if you can live as long, 60 months to get that money back. But if you don't, that's how it works. It is nonetheless an excellent planning tool for couples. Okay, that's couples. And that's how we qualify a couple, one person of the couple for Medicaid without having to spend down money. If you go to an attorney and they go, "Oh, I'm sorry, all you got to do is spend down your money," that's not satisfactory.